The Lagos State Judicial Panel of Inquiry on Related Abuses resumed sitting on Friday to deliver its decisions on 35 petitions after more than a week of recess. Now, these cases were initially set aside from the total 235 petitions before the panel because they were matters that had already been heard by courts of competent jurisdiction. The common factor in these 35 petitions is that the petitioners had sought the panel's intervention for the enforcement and payments of monetary compensations previously awarded in their favor by either the High Court or Federal High Court against the Nigerian police force for proven abuses of their rights. TVC News gathers that the total of these monetary claims goes to about 2 billion naira, far above the 200 million naira fund set up by the Lagos State government to compensate deserving petitioners. In petitions such as that of Ibrahim Kabiru against ENDSARS, the panel says it found that there was no pending appeal by the Nigeria police against the award of 200 million naira to the petitioners, amongst other findings.
2, that the judgment is still subsisting, valid and enforceable. 3, that the state and federal governments of Nigeria have committed themselves to paying the sum due to victims of human rights abuses as expressed in the judgment. 4, that the legal process of enforcement of the judgment has been complied with by the applicant and exhausted. 5, under and by virtue of section 287 of the 1999 Constitution, judgment of court is to be complied with by all persons and authorities.
Also in the petition of Philip Enwerem and Benjamin Nwabuzo, the panel recommended the payment of 10.5 million naira award for the extrajudicial killing and unlawful detention of the victims by ENDSARS operatives, which had earlier been awarded.
A sum of 10 million naira being the sum awarded by the court in the above judgment should be paid to the petitioner, that this recommendation should be forwarded to the federal government of Nigeria.
They adopted what was already there, the recommendations and the judgment of the court. Well, we are yet to see the action. When we see the action, we cannot tell you we are satisfied or not, because for now it is paper.
The panel also called on the National Assembly to review Section 84, subsection 2 of the Sheriff and Civil Processes Act, which imposes the consent of the Attorney General of the Federation or state, as the case may be,